Welcome to this week's edition of Florida Appeals Journal. I'm Jennifer Carroll, and each week we address issues that are of significance to all trial lawyers, to appellate lawyers, and they can concern procedural matters or substantive. And if there's a week that maybe some case came out that's pretty important, we try to bring that to everyone's attention as well. I want to tell everybody, I hope everyone is doing okay with our recent events and the recent world environment we find ourselves in. But litigation goes on, moves forward. We're all moving forward in this. So let's do the best we can and do some great work for our clients. This week, I want us to talk about an issue of high importance, particularly with the family law attorneys and family law clients, and that is attorney's fees. Let's start with the basics, and we'll try to list some of the key cases also as part of the journal entries for your convenience. Fundamental principle, and I think every practitioner knows, any determination regarding an appropriate award of attorney's fees in a dissolution action and support child custody, it always starts with Section 61.16, Florida Statutes, right? Everyone knows the Rosen case, 696 Southern 2nd, 697, Florida Supreme Court, 1997. Listen, several factors. The key principle, though, when dealing with attorney's fees in the family law arena is to ensure that both parties will have, quote, a similar ability to obtain competent legal counsel. And you want to assure that one party isn't limited in the type of representation that he or she receives because that party's financial position is so inferior to the other party. And one thing to remember on this, because it's a tricky thing. I mean, the judge always has to weigh need and ability to pay. Sounds like it's pretty straightforward, but it's not. And that's why I always say keep up with the latest cases on the issue because it's always being clarified. It may seem simple in the statute, but it never is. What constitutes need sufficient to warrant fees, what constitutes ability sufficient to be forced to pay fees. Not an easy question, not an easy resolution. A couple things you want to remember. A lot of trial courts and attorneys think, well, disparity of income, that takes care of it, but it doesn't. The trial court cannot award fees based solely on disparity of income. And I'm going to quote a couple cases, Berg v. Young, B-E-R-G v. Young, 4th District, 2015, that's 175 Southern 3rd, 863. That's a really good case, gives a really good explanation of that with some other key issues. And I think we addressed that in a prior video. Another thing to remember when we're talking about this is the court is required to make specific findings of facts on need and ability. So keep that in mind. If you don't have that, then if it goes up on appeal, the appellate court's not going to be too happy with that. And they're going to think, hey, this is way too vague for us to even make a determination. So, but we'll get back to that. So that's the standard, right, for awarding attorney's fees in the dissolution cases. That's the fundamental principle. And I want to alert you to a new case that came out. It's called, the title is Stewart, S-T-E-W-A-R-T v. Stewart. And that is the Florida 1st District Court of Appeal, 2020. And that was an interesting case because the appellate court held the former wife was not entitled to an award of appellate attorney's fees that she had actually received in the trial court. It went back on appeal. And the former husband had appealed the award of the former wife's entire amount of appellate attorney's fees. And what the trial court said is, well, the former husband had the ability to pay the fees due to his ownership of an airplane and ownership of an investment account. All right, so I guess that put him in the superior position to pay. But realize that those assets were previously included in the equitable distribution. and there have been, an equal distribution of assets and liabilities between the parties. Now, the trial judge in that case made no findings to support the former husband's superior position from income or other source outside the equitable distribution scheme. And that's always important because that controls everything, is that equitable distribution. So the court held the grant or denial of a motion for attorney's fees must avoid, quote, the inequitable diminution of a spouse's share of an equitable distribution. We all know that. That's pretty fundamental. If the equitable distribution scheme places the parties in substantially the same financial position with equal abilities to pay attorney's fees, then it is an abuse of discretion to award fees to one former spouse. Now, in that case, the appellate court found that the trial court made no written findings that after the equitable distribution, the former wife needed any assistance from the former husband to pay her appellate attorney's fees to ensure that her ability to retain competent appellate counsel was similar to the former husband's ability. And again, it goes into the very purpose that I led off with. So the court said, so even if the former wife established her need for assistance, the order on appeal lacks any indication that the trial court considered whether former wife was able to pay in some portion of her fees without suffering an equitable diminution. So I recommend that case, a very recent case, that again, always clarifying, these appellate courts are always clarifying what this standard really means in the practical day-to-day operations of these issues in the trial court. So the appellate court there reversed the order granting the former wife's appellate attorney's fees in full, again, because the order required former husband to pay all of those fees based only on the fact that he had the ability to pay if he liquidates certain equitably distributed assets. So that's actually a really good clarification of the standard. So I want to tell you the tip of the week. I try to do a courtroom tip of the week. So related to these cases is you want to make sure that the judge does make those findings, specific findings of need and ability to pay. So when you're doing your proposed order, you're going to want to put that in if you want it to withstand judicial scrutiny. That's very important. And a couple other things, just remember, put those invoices into evidence. I keep seeing cases where attorneys are relying on just the testimony, but you really need those invoices in. So I want to throw that in. And also with proposed orders, put them do a notice of filing and put them in the record, because it's always interesting on appeal if the trial judge just signs off on an order without making any changes. It does affect the standard of review. The appellate court's not going to give as much deference, really, if it's identical. So just keep those. I gave you more than one tip, but it's just so tempting. So if you have any questions, email them to us. The email is on the site. And if there are issues that you want to see addressed, by all means, let us know. Thank you again for your time, and good luck this week. Thank you. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.